Mr. Chair. I'd just like to follow up Trevor Mallard's interesting speech in relation to Clause 16 of Part 2 on conflicting claims, that is, envisaging a situation where there might be more than one person entitled to an annuity. And I think that reflects back, as Trevor Mallard said, to we're in a modern society. It's a modern clause, and there could be not only two spouses in terms of one dying and perhaps the Governor-General remarrying, but it could take account of divorce. And if you look back into the history, particularly the history of the monarchy, including the Governor-Generals as part of it, it was a history that was quite averse to divorce, and until death do us part of the marriage vow was not only an intention, but very strongly part of the moral code of society, and very much tied up with religion. So to have this Clause 16 here is a very modern thing to do, and I think it's getting away a little bit from the strictures of religion that have so shaped our constitutional history in some ways a too narrow manner. And even, in fact, earlier this afternoon we had the prayer in Parliament, the prayer that's been read for many years, and in that it uses the term true religion, which is a phrase that dates back in British history in British parliaments to the 1600s. And true religion means the Protestant religion, and it's the reference to true religion is Protestant religion against another religion, that is the Catholic religion. That's the origin of the prayer that we hear in Parliament each sitting day. So it's and that true religion was associated in the Protestant tradition with a very strong tie to against divorce, to marriage for the rest of the couple's life. So this Clause 16, in allowing something different, is quite progressive. I think that also when we have, I think Trevor Mallard's comments about the multicultural element of this clause were quite relevant too, that there are various religions with different codes of marriage and divorce, and they will be taken into account as part of our multicultural dimension. And I think that also when you talk about religion, moral codes, how they're reflected in this, you've also got to talk, and Phil Twyford in the last speech did, about, and I think he was talking about really the outdated character of the monarchy that the Governor-General is a part of. And one of the aspects of that, and one of the problems with changing the laws of inheritance, which Gordon Brown, to his credit, wanted to do it, he took the matter to a Commonwealth Prime Minister's conference before he lost office, is that the monarch in Britain is officially the head of the Anglican Church. And so they can't have someone who is not an Anglican, and they can't have someone who's converted to Catholicism to be their head of state, because that person isn't an Anglican. And that offends against our human rights laws and our ethos. Yes, Mr. Chairman, and I think that all relates back to this very modern clause, Clause 16, that allows for conflicting claims relating to the annuity for spouses following, for example, the death of the Governor-General. Thank you.
Call Grant Robertson.
Mr. Chair, I too wanted to refer firstly to Clause 16 and 17, because while I appreciated Mr. Hayes' intervention to clarify his interpretation of that particular clause, while that may have dealt with some of the issues that Mr. Mallard raised, it certainly didn't deal with all of them, and definitely didn't deal with his in principle issue about Clause 10.2, which we have has seen no answer from the Minister on. But I do think the circumstances in which there could be conflicting claims are actually reasonably simple in terms of the way that we live our lives in New Zealand, beyond any extension to the possibilities of the backgrounds of the kinds of people who might become Governor-General at some point. Basically, this is really just about a situation where there may potentially have been two partners of a Governor-General during the period in which the person was Governor-General. And that's actually quite a reasonable circumstance to imagine, Mr Chair, that somebody may enter into a relationship. The job of Governor-General is a stressful and difficult one at times and has long hours, and that could in fact lead to somebody separating and then there being a new partner. So I think the issue of conflicting claims is a sensible clause to have within the bill, but it actually is about something potentially quite real. While on that point, Mr Chair, it is worth noting that this is a very modern piece of legislation. It lists in Section 4 the definition of partner, meaning a civil union or de facto partner. So the bill brings us forward into the 21st century in terms of the kinds of relationships that people can be entered into. So I think Clause 16 is a sensible clause, but I take the point from Mr Mallard that if we move through to Clause 17, the question of who is the person that makes decisions around this matter is something that's up for debate. And again, in the interpretation section of the bill, an authorised person means a person authorised to make decisions under Section 16 by the Minister, who, with the authority of the Prime Minister, is responsible for ministerial services. Well, at this moment, that's the Prime Minister, and so the Prime Minister will be appointing a person to listen to such claims. And I agree with Mr Mallard that a public servant placed in that position could be placed in a very difficult position in making those sorts of decisions. They may be a public servant who has a role perhaps subservient to the Minister responsible for ministerial services, and I think that could lead to some unfortunate pressure being placed on a public servant to make that kind of decision. And it will be a decision that, if one can imagine the circumstances I mentioned before, something that people would be particularly concerned about, and it would no doubt attract a great deal of public interest, and it would be a matter that the person would have to take very seriously. I do note in clauses 17, 2 and 3 there's a reference to various rules that will apply, in particular the High Court rules, the Judicature Act, and relating to appeals to the Court of Appeal and against a decision of the High Court. So there's clearly a judicial element to this role, and I think it is important, Mr Chair, that if someone is appointed to it, there's somebody who can be independent and who can take decisions like this without any particular pressure. Mr Chair, the other clauses in Part 2 that I want to refer to in particular are clauses 25 and 26. And I do this because throughout the debate a number of people have mentioned the current Governor-General and what a nice person he is and how he's related well to these proposed changes, and I absolutely endorse those comments. He is a great New Zealander, Mr Twyford. But I do think it's important to note that Clause 25.2 in fact exempts the current Governor-General from the incumbent Governor-General from these changes in this Act. In fact, 25.2 specifically says that all of the Governor-General's allowances are as if this Act has not been passed. So while it's worth saying that the current Governor-General is a humble man, and he's a person we all greatly admire and who deserves our support at any occasion, he actually isn't going to be covered by this particular law, although under Clause 26 the annuities are in fact in accordance with the Act. So I guess from a sort of the point of view of a buyer beware situation, the Governor-General is already in the situation, and therefore the conditions on which he took up his position are being protected, but his annuities at the end of the day are not. So while I think we all see this as a good step forward, and also in this part we are dealing, Mr Chair, with the changes to the Income Tax Act, those are not actually going to apply to the current, the incumbent Governor-General, who doesn't have too much further to run in his term, but it is something that a number of members have mentioned and I think was probably important for us to clarify. So Part 2 really does put in place what has been done in Part 1 in this bill, and while the Labour Party is supporting this bill, I think it's clear from the speeches we've heard that we would like to see some further conversation on constitutional arrangements.